Good morning, Francesca.
Good morning, Judge. The court can call People versus Westbrook, date and time set for amended plea hearing.
Appearances?
Good morning, Your Honor. Colleen Warren, appearing on behalf of the people.
And good morning, Your Honor. Attorney Brent Jaffe on behalf of Jesse Westbrook, and please accept my sincere apologies for appearing at this time. I had a conflict, and I do apologize.
What are you apologizing for?
Because it was scheduled for 9:30, and I am joining the record after 9:30. So for that reason,
it was scheduled for 10 o'clock, and you're joining prior to 10. So
no apology,
beautiful. No apology necessary. But thank you.
Good.
All right, Ms. Warden, you corrected this or requested this hearing. Why?
Judge, if I could put this on the record, thank you for accommodating us. I sent a referral to probation to defense counsel and he approved it. But as we were going on the record, it occurred to defense counsel that I had offered something different. So I went back and checked my notes and he was correct. So we need to put that on the record.
Well, what did we take the plea on and what did you offer?
Judge, I offered an attempt child abuse second, and we put on the record, and I also put in the referral to probation, which I gave to counsel, child abuse second, not an attempt. So we're just correcting that aspect of it.
Well, I mean, my memory of this is that was the offer at one point, and then on the day we took the plea, you specifically revoked it, or prior to that date. So when did you change back to the attempt?
Judge, I think that the offer has always been an attempt, but when I put it on the referral to probation, I thought that I offered a second, but I went back and looked at my notes and the text messages that I exchanged with counsel and realized that I actually offered an attempt. Again, I just wish that it would have been corrected when I sent it to counsel.
Well, have you been the prosecutor the entire time?
Yes, Judge.
So, you did revoke the offer. I have written down in my file, attempt child abuse second as the offer, and then I have at a later date written next to it revoked. So that happened. I guess you don't remember it. Does that refresh your recollection at all?
Judge, I don't remember ever revoking it, but if I said that in your notes, I must have said it. I don't remember that, nor do I have that in my notes either.
All right. So let's assume, well, that's just a minor point. So how could we take a plea with both counsel present to something that wasn't the offer?
Your Honor,
I'll start with you, Ms. Warden.
Judge, I think that it was just a mistake on the referral to probation. But again, when I submitted the referral to probation, Mr. Jaffe, and I gave it to him 2 days prior to the plea, he said, yes, it's fine. That's good. We're good to go. So I assume that's what I offered because I put that on the referral to probation. But
you assume what is what you offered?
When I submitted the referral to probation to Mr. Jaffe in an email and I e-filed it, I put that I was offering.
Ms. Warden, you broke up. Start over. What is it that you offered?
I offered
that you just referenced in your allocution.
Judge, I'm offering an attempt child abuse second, which is different than.
What did we take the plea to?
Child abuse, not the attempt.
So why did you say there was a mistake on the referral?
Because on the referral, it was child abuse, not attempt.
Well, if we took the plea to child abuse, then the referral's correct, right?
Well,
no, Judge, the referral says child abuse on it, not attempt child abuse.
Judge.
I mean, am I not speaking English?
Your Honor, may
no, you may not. You may not interrupt me, Mr. Jaffe. So you're saying we took the plea to child abuse second, not attempt. Is that
correct.
Right?
That's correct.
All right. And then the referral says child abuse second, correct?
That's correct, Judge.
All right. So the referral is exactly correct. We took the plea to child abuse second. And now you're saying that you wanted it to be to attempt. And I'm going to go back to the original question I asked 5 minutes ago. How could both counsel be at the plea? We go through everything and it's child abuse second and not realize it was attempt. Were you both very grievously mistaken? Let's start with you, Mr. Jaffe. You had something to say.
Thank you, Your Honor. Well, I just want to say that this is a very complicated case, Your Honor, and there are a lot of moving parts. And I would say that between myself and Ms. Warden, we've had very, very fruitful and ongoing conversations in terms of reaching a resolution in this case. Again, I think Ms. Warden has
Well,
been...
congratulations, but that's
Yes.
not the question I asked.
So, Your Honor, here's the thing. At the plea hearing, when we placed the plea on the record, I did actually state on the record I thought this was an attempt, and then there was some discussion, and then we proceeded with the straight child abuse second. I think ultimately, again, Your Honor,
did Miss Warden say on the record, to your memory, that the attempt was previously revoked?
I don't recall her stating that it was previously revoked on the record, Your Honor. No.
Well, I'll be listening to the record, but in any event, so then what you're saying is you all thought it was supposed to be attempt, but then we got into the plea and that wasn't on the table, and you continued and your client pled to the child abuse second. Is that what I just said?
That is what occurred. That is correct, Your Honor.
Right. And now I remember that conversation. So, Miss Warden, you specifically addressed what the plea should be when counsel thought there was a mistake. And you said, no, we're going with child abuse second. How did that happen?
Just because I submitted the referral to probation to him a couple days in advance, and I said, is this your recollection of the plea? He approved it, and then I e-filed it. So I assumed that was the plea. But then when I went back and looked at my notes, that's not what the plea, that's not what I offered. So I thought in good conscience I should offer him what I promised him in the first place.
Right. And that's all fine, but it's surprising to me that you don't remember specifically revoking that plea sometime prior to the day the plea was taken. And then when that was brought to your attention, you affirmed that it was child abuse second. How'd that happen?
Judge, I don't recall revoking it. Again, we've gone back and forth on this with Mr. Jaffe and I. And I also had to go through my administration to get this deal. So there have been multiple conversations we've had. I really don't remember ever revoking this. I know that we put on the record, I have on the notes in my file that we put on the record at least 3 or 4 times that we were very close to a plea, but we were working out the different issues.
No, I know that, but obviously you revoked it because when Mr. Jaffe pointed out your error during the original plea taking, that it's supposed to be attempt, and you said no, it's straight up to the child abuse second. Anyway, you both have wasted enough of my time with this, so let's go ahead. So what do you want to just take another plea?
Well, Your Honor, yeah, and if I could just clarify for the record, Your Honor, in my ongoing dialogue with Ms. Warden, she never revoked the attempt second. So again, with all due respect, Your Honor, I've had an open line of communication with her, and there was never a revocation of that plea, and there was a specific reason why we negotiated the attempt as well. Again, human error, Your Honor, and please just respectfully, that's where we were coming from on the date of the plea. There's a little confusion on both of our parts.
It's your human error, counsel. It's a collective error of both counsel.
Perhaps.
It was revoked. Maybe even, I don't recall the timetable. I know what I wrote. I didn't make that up. Maybe I wrote that revoked during this plea when you brought up that it should be attempt, and she said, no, child abuse second. Because in our prior discussions, I'm sure it was discussed. That's why I wrote that at 2 different times. plea to attempt child abuse second offered. Then at another point in time, I wrote revoke. So I again, this is a colossal waste of time in my mind. So anyway, put the plea on the record, Miss Warden.
Thank you, Judge.
Well, the problem was that the referral that they gave to him had the offer that was pled to. So what he knew after, after the offer was rescinded, apparently, was this was the final deal, because they said they have gone back and forth. But he is over the top, in my opinion, like way over the top. This admonishment did not have to go down this hard. Yeah, they screwed up, and yeah, it's their human error. But for crying in the mud, the poor prosecuting attorney, she's like on the verge of tears right there. And when you hear the details of the case, it's going to break your heart worse. I'm warning you, it's going to break your heart worse.
People move to dismiss counts 1, 2, and 4. The defendant will be pleading no contest to count 3, which is resisting and obstructing, MCL 75081D. It's a 2-year felony. And added count 5, which is attempt child abuse in the second degree. That's MCL 750136B3, and that is a 5-year felony. The no contest is due to civil liability.
Correct recitation, counsel.
That is correct, Your Honor. We also did have a Cobb's evaluation with Your Honor that you would impose a sentence consistent with the probationary term, but just to place that on the record as well, pursuant to the Cobb's evaluation.
And also, just in case Miss Warden forgot this, the prosecutor indicated on the record last time there was no objection to the sentence, and there would be no appeal to the Cobb's, rather.
No, Judge, I didn't forget that, and yes, I do agree with that.
All right, swear the defendant.
Mr. Westbrook, please raise your right hand. Do you solemnly swear or affirm that the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, sir.
Jesse Westbrook.
Do you understand all the rights your attorney has explained to you in connection with this plea?
Yes, sir, I do.
Right, and counsel previously got a signed advice of rights. You're to get another current signed advice of rights to the court, counsel.
Will do, Your Honor.
It's my understanding, sir, that you wish to plead no contest to the charges of attempt child abuse second and resisting and obstructing a police officer. Is that right?
Yes, sir.
Do you understand the maximum penalty on the attempt child abuse second is up to 5 years in prison?
Yes, sir.
And on the resisting and obstructing, up to 2 years in prison?
Yes, sir.
You also understand your attorney's negotiated a Cobb's agreement with the court whereby I've agreed to a sentence of no additional jail.
I do, Your Honor.
Right. Do you understand the plea bargain agreement, sir?
Yes. To the better of my knowledge, I've understood Mr. Jaffe's explaining everything to me.
What does that mean? It's a
That
yes or no question, sir.
Yes.
Okay.
Your Honor, can I just ask my client directly?
Go ahead.
Mr. Westbrook, you and I have had multiple conversations about this plea agreement. Is that correct?
Yes.
Okay, and you're satisfied you understand this plea agreement, correct?
Yes.
And you understand that by pleading no contest, you're acknowledging that what you pled no contest to is what we've spoken about and what you understand, correct?
Yes.
Okay, thank you.
Plea agreement, sir, is you're pleading no contest to the two charges we discussed, correct?
Yes.
In return, the prosecutor is willing to dismiss counts 1, 2, and 4, correct?
Yes.
Is that the complete plea bargain agreement, sir?
I believe so, yes.
What do you mean you believe so?
Yes, Your Honor.
All right, the answer to my question is yes.
Yes.
Is everything you expect from the plea bargain agreement set forth on the record?
Yes, it is.
Are you accepting the plea bargain agreement of your own free will and choice?
Yes, I am.
Have there been any promises or threats to get you to plead no contest today?
No, Your Honor.
Do you understand you will not at a later date be able to claim there were promises or threats that caused you to plead no contest today?
Yes, sir.
Have there been any such promises or threats, Ms. Warden?
No, Judge.
Mr. Jaffe?
No, Your Honor.
For the record, I personally think that this man should have taken this to trial.
How do you propose to establish the factual basis?
Judge, I'm going to establish it through warrant complaint number 21-50364, which is encompassed in its entirety, including the medical report. May I go ahead?
Yes.
On October 9, 2021, the defendant fell asleep in a recliner at the address of 13037 Prospect and Warren. The defendant's 3-month-old son fell asleep and asphyxiated in the chair. The defendant was intoxicated, and he did have care and custody of his son at the time. With respect to the R&O, as the Officer Serafino was escorting the defendant to the vehicle, the defendant began to yell, refused to cooperate with the police. When the police tried to put him in the rear of the police vehicle, he attempted to get away and spin away from the police officers and did not cooperate.
All right, so stipulated, counsel?
Your Honor, again, I'm going to make the same objection that I did at the initial plea hearing. Your Honor, in terms of the cause of death, I'm going to challenge the asphyxiation because per Dr. Spitz's medical report, the cause of death was indeterminate. So, and he did not in fact opine that the cause of death was asphyxiation. So in terms of that, I would object, but everything else I would agree with. So again, in other words, I think that the cause of death as established by the autopsy report should be the factual basis in terms of the cause or nature of death of the child.
It will not. I will accept the police report as the factual basis, and I'll overrule your objection.
Your Honor, I appreciate that, Your Honor. However, last plea hearing that we had, Your Honor did acknowledge what I stated, if I recall, and ruled consistent with the medical examiner report, and not the cause of, and not the asphyxiation as far as cause of death.
What does the autopsy report say?
So the cause of death says unknown. However, during testimony at the preliminary exam, the medical examiner did testify that the cause could have been asphyxiation, but I don't think that is integral to this plea hearing. That the baby did die. Of course
it's not. You dismissed the homicide portion of the charge.
Yes.
So, all right, in any event, given that fact that Mr. Jaffe just brought to my attention, I'll strike that prior ruling. We'll accept the autopsy report as the cause of death. None of that is relevant to the elements of the two charges you did plead to. You're stipulating to everything else that Ms. Warden said as the factual basis, Mr. Jaffe?
Yes, sir. Yes, Your Honor.
So the court's satisfied as well. Mr. Westbrook, to the charge of attempt child abuse, second degree, how do you plead?
No contest.
Court will accept the plea, no contest. Resisting, obstructing, how do you plead?
No contest.
Court will accept that as well. I'll refer to probation for a pre-sentence report. I'll set sentencing for
February 15th at 9:30 via Zoom.
Okay.
And Judge, are we setting aside the previous plea?
Yes.
Thank you.
And I am in trial that week. Is there any possibility we could push it to the following week?
Sure.
Thank you.
Judge, we can do February
Madam Clerk.
February 22nd at 9:30.
Thank you, Judge. And Judge, thank you for accommodating us. I apologize for our errors immensely.
All right. I accept your apology.
Thank you, Judge.
You're welcome.
So February 22nd. Thank you so much. Okay.
Thank you.
All right.
Bye-bye.
Bye.